My name is Paul Avalar. I'm an attorney with the Institute for Justice. I'm here today because part of what I do is sue to protect the right to earn an honest living, as you may remember from this morning with the Arkansas hair braiders. I'm testifying mostly about the standards of review question, because last time this bill was debated there were a number of questions related to that, and I'd like to touch on those. The bill itself says not compelling state interest. The bill says that an interest has to be important, and public health and safety is certainly important. What the real issue with the bill is, where it really does its work. Oh, I'm sorry.
You have a point of order, Representative Womack.
Point of order, please.
Yes, sir.
Can I reserve at least 1 minute for close?
We will throw our hands up when there's 2 minutes left, when there's 8 minutes used. Yes, sir.
Thank you, sir.
Mr. Avalar, go ahead. I'm sorry.
Thank you, Mr. Chairman. Where this bill really does its work is when it says that the government is tasked with proving that its rules and regulations are the least restrictive means to further the public interest in public health and safety. The way the law works today, and some people have asked, well, can't you go to court today? Yes, you can, but as a practical matter, no, you can't. Today, occupational licensing laws, any laws that affect economic liberty, are subject to what the Supreme Court has called rational basis review. The joke amongst lawyers like me is that rational basis review requires neither a rationale nor a basis. It is essentially a rubber stamp to do whatever the government wants to do. And while that may seem attractive to some, the problem is that many regulations are not in fact written by the legislature. What the legislature does is it passes very broad bills, and then it creates a specialty committee or board to enforce those bills, or to enforce those licensing laws or those other regulations. Those boards are staffed almost entirely with people who are in the regulated industry. And so the people who are running the boards and making state policy have an economic interest in protecting themselves from competition. The legislature, for example, I doubt very much understood that it was licensing the practice of hair braiding when it created a cosmetology license, and yet in practice that is what happened. What this bill does, well, let's talk about what this bill does not do. It does not affect fiduciaries. It says so right in the bill. And so lawyers are not in fact affected by this, nor my understanding is that real estate agents are not affected by this either when they're acting in a fiduciary capacity. It requires an important state interest, but public health and safety is an important state interest. Enriching certain elements of an industry at the cost of others is not an important government interest. And so what this bill does is it requires courts to look at the facts of a situation and determine whether or not what the rule being applied really does is protect some people as opposed to protect the public and protect consumers. Finally, the least restrictive alternative to achieve public health. It's not that every licensing law will go away. That's certainly not the case. It is the case, however, that licensing laws and other regulations will have to be shown that they are the thing that is protecting the public, and that some other less restrictive means of doing so will not protect the public just as well. Reforms to occupational licensing laws are really a bipartisan issue. Governors from Texas to Massachusetts have now called for very significant reforms to occupational licensing laws. Professor Alan Kruger, who served as President Obama's first chief economic advisor during his first term, has called for massive reforms. And the most recent proposed budget from the Obama administration includes $15 million for states to analyze the costs and benefits of their licensing rules. Because, in the words of Betsy Stevenson of the President's Council on Economic Advisors, quote, "We would like all states to ask whether licensing requirements meet a cost-benefit test," unquote. Many licensing laws today do not. I'd note also that licensing laws, as was indicated earlier, tend to fall heaviest on the poor, on women, on immigrants, minorities, people who don't have the sorts of resources that it takes to oftentimes meet and achieve these licenses. And so with that, I'd like to answer any questions that this committee has.
I guess I have a question is, why would you want to target all boards instead of just boards you see as a problem? And I think the hair braiding bill this morning is a perfect example because you could have sued and accomplished what you did this morning.
We did sue. That's obviously what prompted the case. Again, the ability of a lot of people to sue for what are patently ridiculous laws is very much limited by the current jurisprudence on constitutional issues as it relates to economic liberty. Maybe the best example is a case that we did out of Louisiana. Louisiana is the only state in the nation that licenses florists. To be a florist in Louisiana, you have to have the approval of the floral board, which consists entirely of other florists. We represented a woman named Sandy Meadows who had been a florist for years but didn't have a license. And the state of Louisiana threatened to shut down her employer unless they fired her because she was not allowed to arrange flowers without the state's permission. When we sued, the judge said that, well, the licensing florist was perfectly constitutional, notwithstanding that every other state in the union doesn't need to do it, because there could be infected dirt on a flower somewhere, and that a license...
Excuse me, there's 2 minutes. Do you want to let him continue, Representative?
Okay, I will wrap this up. The judge said that there may be infected dirt somewhere, and maybe a license could help alleviate that threat to the public. This, despite the fact that there was no evidence of any infected dirt anywhere, and nothing in the licensing exams tested florists on infected dirt. This is the sort of problem, the sort of hurdle that entrepreneurs and workers have to overcome today under current law. What this bill does is it gives them a stronger voice to fight against rules that aren't really meant to protect the public. Thank you very much.